Hello, viewers. Welcome to another episode of It's a Learning Curve. Uh, Today, it gives me an extreme pleasure to welcome my friend, Mr. Rajesh Jadhao, who is going to emphasize on talking about the patenting process. Many of us have a lot of innovative ideas, but we lack in how to commercialize it or how to put it in market, and patenting would be the first step for it. So, Rajesh will give us deeper insights on how a patenting process works. So, without taking a lot of your time, I would request Mr. Rajesh Jadhao to go ahead and please self-introduce himself.
Hi, Trupti. First of all, thank you for having me. Myself is Rajesh Jadhao. Right now, I'm working as a patent attorney with one of the leading law firm in India. Prior to that, I did my master's in chemistry, uh, which I then followed by my research at National Chemical Laboratory in the field of catalysis. So my basic technical background is chemistry, and uh, for last more than 5 years, I'm working as a patent attorney.
Oh, that's awesome. So, I know there's not going to be anybody better than who is you, who is currently working in patent processing, and it would we are looking forward to know a lot of things and looking forward to have your thoughts on how all these things work. So, can you just in short tell us what exactly a patent is?
Yeah, sure. See, a patent is a form of intellectual property, the owner of which actually gets a legal right to exclude others from practicing that particular patented invention or selling it or making that particular product or even the importing of the patented invention. This particular right or legal right to the patentee is for a limited period of time, till the 20 years basically in India and most of the countries all over the world.
Okay, so in short, it is a time-based protection of our innovation or ideas. That sounds
Absolutely.
perfect. So I'm sure there should be a lot of multiple steps involved, right from having an idea uh, and putting it through to a patent. So, can you just give us a short description on what steps are included in getting a patent out?
Sure. Before I go on to discuss the steps those are involved in patenting an invention, let me put some light on the criteria for an invention to be patented. Okay, so basically there are three main criteria. One is the novelty, the other one is a inventive step, and the third one is industrial applicability. Novelty is the invention to be new. Inventive step, the invention should have some technical advancement or the prior arts, or it should not be obvious to a person skilled in the art. Okay. The third one is industrial applicability. So it should be able to commercialize or should be able to practice at the industrial scale actually. So basically these are the main criteria for an invention to be patented. Now, basically there are few steps which are involved till the grant of the patent, uh, after which actually the applicant as per his interest can maintain his application or a patent. Of course, the first and foremost step would be applying for an application for a patent. After application, uh, the application is not published for a certain period of time. Like
Hmm.
in India and I think in US also, it is not published for 18 months. So, but in that particular case, wherein the applicant wants the early publication of his application, he can go for a early publication by filing particular form with prescribed fees. Okay. After the application is published, after the 18 months are expired, it goes under examination stage. For the examination, applicant has to request the patent office for an examination. So until and unless he don't request for an examination, application would be examined
Okay.
after the request for examination, and this can be done for particular time period, like till 48 months of from the filing an application, an applicant can request for an examination. Once the examination is done, so from there actually the prosecution of that particular application starts, and it has few similar steps like examination and then response from the applicant. Then, if any objections are remaining with the controller, he can again issue an examination report, and accordingly the process goes on till the response satisfies the controller or the patent office, and
Okay.
subsequently the patent get granted actually. And after once the patent is granted, uh, the applicant has to maintain that patent by filing yearly fee or maintenance fee kind of thing.
Okay.
So
So,
these are the broad steps which are involved in patenting an invention.
okay. So, would you like to elaborate more by splitting up the steps? Like, is there any invention disclosure involved? And after the invention disclosure, provisional patenting is involved, the filing of provisional patent, and then comes the real patent. So, are these different steps which you were talking
Yeah,
about?
see, yeah, see what the steps that we have talked of right now are basically pre-steps of filing an application. Okay, and these are most concerned with the inventors or the innovator who wish to file a patent at the patent office.
All right.
Now, as I said, like we really have to be very sure that the invention we are speaking of is patentable under those three main criteria. Now, doing these things actually, uh, we the most important part of the patent is the claims. Claims specify your product or a product process for which you want the right for it. You want the legal right for that particular product or a particular process. So accordingly, you need to draft an application based on your invention. The most important part would be the experimental part, which is being given in there, because it should uh, support your claims substantially, because it will give you an idea to a reader that the invention works in that particular manner. And again, there are few further limitations for an invention to be patented. See, basically claims and the specification, whole of the specification. Once any a person skilled in the art reads the invention, he should be able to practice that invention in the lab as such, and he should not feel undue pressure in practicing that invention. So accordingly, you need to come up with the specification. So basically, it's a part of drafting the specification overall. The claims part is most important because this is the part where the applicant is most interested in actually, because this is the part for which actually the applicant gets rights to exclude other from practicing the invention or using or selling it or importing it. Uh, so wherever any inventor, if he is not filing the application on its own, the most important part would be to preparing an invention disclosure, because
Okay.
you wanted an attorney to be filing your application for you. So the most important part for him would be drafting the invention disclosure to give a basic idea or give
Hmm.
a better idea to the patent attorney to go with drafting the claims and the specification.
Okay. Yeah, that makes it a lot of things clearer, and it clearly says that specificity of your process is very important so that you can practice it in-house, but you can still protect it. Yeah. So, going to the next question, what is the role a patent or attorney like you play in this entire process when we inventors come to you and file the patent for protecting our IP?
Basically, patent attorney helps the client to prepare a strategy or a tactical planning necessary to implement the agreements associated with the patents. So these are the broadest way in which actually the patent attorney helps the clients. Now, starting from, because patent field involves a lot of steps. It is not only filing an application at the patent office, but the other searches like novelty searches or freedom to operate search or landscape. There are kind of searches, uh, and the attorney can help you in doing these searches, coming up with the research you are interested in. Basically, I can go example by example. Like if you really wanted to know if your invention is novel, is really new, then you can go for a novelty. The other thing is, if you wanted to practice some invention without patenting or with patenting in any of the way, and you do not want to infringe anybody's else patent, in that particular case, the most important for you would be to do FTO search, freedom to operate search. Now you know that patent is basically valid for 20 years time period. So FTO becomes limited for that particular 20 years time period because you really don't want to infringe anybody's patent. Okay. So starting from searching to drafting or filing an application of the invention at the patent office, an attorney can help you because uh, attorney is basically expertise who is working in that particular field. He
Right.
can further help you to obtain a grant for an application because it really require a lot of steps to go till the end uh, to get a grant to an application. So the first and foremost thing would be drafting an application in which, uh, as per the interest of the applicant, attorney can help you to draft the broadest claims. The thing is like you should get a uh, broader scope of the claims, but you should not go beyond the scope of the invention actually. So it would require you a tactics and strategy to draft those claims. Then there are some clerical works like filing an application at the patent office, and then comes the technical part like if an examination report is issued against your application, you need to file a tactical response so that it goes through, the application goes through. Further, again, there is one more step, particularly in India, there is a hearing stage after the examination, which is basically you have to file a response to that particular examination report in writing. And this is all done at e-filing mode, like online everything. But at a hearing stage, you need to be present with the controller. Physically, you have to be there. It could be, it can happen through video conference, and mostly right now in India, mostly the video conferences are more preferred things because everything is centralized. So accordingly, you need strategies to amend those claims to see how we can narrow the scope of the invention or how we can change the scope of the invention so that we are through the objections those are cited by the examiner. So that way attorney can be helpful to the inventors or to industries at different levels of patenting.
Okay, perfect. That apparently means attorneys really play a significant role in the entire patenting process, and it's only going to help the inventor to have a stronger IP. Yeah. So, regarding this, I would like to ask, So the patents are usually territory based, like an Indian patent or a US patent. So if it is a territory based patent, does it allow me to use it in different territories? So if I have a US patent, can I go ahead and use this process without any restriction in a different country?
Yeah. Okay. See, patent is a jurisdiction specific. Now, jurisdiction mostly comes with your country of origin, basically. Now, patent has to be filed jurisdictionally. As you said, it is a territory based. Now, if I file a patent in India, uh, any other person without my consent can use that particular in patented product, but I have only patented it in India, so he can use without my consent.
Okay.
Okay, so this gives you an idea, like it is a territory based thing. Like wherever your interest lies, you need to patent it separately in that particular countries or particular territories. Now, in this particular case, now there is a cooperation between different countries all over the world, and there is a centralized system. We call it as a WIPO, basically. There is a treaty between the countries. Now, if an Indian wants to file an application in some foreign countries, so there could be two different strategies as per his interest. The one thing is like he can file an application in India, and within 12 months from the filing date, we call it as a priority date of an application. He can go in different foreign countries. We call it as a convention application. So those are the convention countries, basically, because the application filed in those countries are filed based on the priority date of the Indian application.
Okay.
This basically happens when the applicant is interested in going only for 2 to 3 countries or a lesser number of countries, actually. So it is better to go direct to those convention countries directly. But in case the applicant is interested in filing the application in large number of countries, even say 8 to 9 countries of his interest, it is better to go with a centralized system. And this centralized system is a PCT, basically. So after filing an application in India, within 12 months, you have to file a PCT application at WIPO within 12 months. And once you are done with filing an application at international level or international application as PCT, you get a time period of 31 months from the date of priority date to go and choose your countries of your interest. Now, because you have got a bigger time span, you can the applicant can think of his interest and then proceed to enter national phases in different countries. Since it is a centralized system, many of the documents which are filed at the international level are directly being transferred to those particular countries. So even the documentation is less. Even PCT can help you with initial search report, basically, which is called as the International Search Report, ISR, which gives you an idea of the prior arts available all over the world, uh, which you need to take care while you can take it uh, while entering the national phase. You can amend those claims on record so that you go through those cited documents cited by the international authority. So basically, depending on the interest, we have two ways of going out at the different countries.
That's actually excellent. We really have a strong system established where we can definitely protect our IPs and protect our inventions at different levels in the world. So, yeah, definitely that's a great thing to know. And before we leave, I would like to ask you if you have a take home message for our future innovators.
Oh yeah, sure. what I can say, like there's a famous proverb, patent or you perish, actually. So basically, if you really wanted to safeguard your invention because it is your intellectual property, even though it is not in the form of a physical property, but it is your property, and you need to safeguard that property. So it is always better to go for patent before uh, publishing that intellectual property in public. So yes, actually, the other thing I would say, by patenting an invention, you are also helping or supporting the development of your country. Because if you see the number of patents which are filed by different countries, developed countries like US or European countries or Japan are far ahead as compared to India. Now you see, China wanted to go to a large extent actually, and China has increased the number of filings internationally was very large extent actually. So it is better to safeguard your invention, and you should be benefited for your property, your intellectual property. Thank you.
Yeah, definitely. So it really gives a strong message that it not only protects your intellectual property, it's an abstract property, but it's still your property, but it also helps in the betterment of your country. So definitely, all you intelligent innovators, I would definitely recommend you to always go ahead and at least go ahead and file an invention disclosure where you are one step ahead in protecting your IP. So, thank you very much, Rajesh, for educating us through the entire process. And we have now understood a lot of significant steps and a lot of things that we need to take care at our stage and what an attorney can do for us to help to protect our IP. So with this, I would like to thank you all viewers for your support, and I request you all to keep liking, watching, and subscribing my videos, and please stay tuned for more such informative and educational videos. uh, until the next segment, stay tuned and always remember, it is a learning curve. Thank you so much.